Lord, I have spent my 17 years, and 1 year I did not earn a single paisa. I did not do any case in Calcutta High Court. Any private matter. I spent from my own pocket. This CBI has powerful because of my exercise.
That trial has been completed.
No, I am telling you, I was 19, no trial. 2001, 24 years, no trial. Rianur Rahman, 2007, no trial. Then other cases, no trial, nothing. Only I have said in other cases, Khichberi photo. Point is, when an investigation is defective and when an investigation is conducted in a biased manner, whether the High Court is having the power to direct, to transfer the investigation. Ultimately, Supreme Court has said, yes, Article 226 and Article 32 of the High Court, power of the High Court and Supreme Court is there to direct the transfer of an investigation, right? What my learned friend has submitted, that's a complete destruction of evidence. I have no what lordship is there. And it comes to a prayer of God. Consider this.
और एक है ये नेक्स्ट
The least of in the nature of magnanimous plea of commanding the respondent authority to initiate further investigation of the instances being important number shown to the 13 August to under this investigation concluded charge sheet 5 criminal
former year
delivered. But therefore, there cannot be any further investigation in connection with it. The destruction of this evidence and anything is there post what your lordship was suggesting, post crime after the offense. Not in connection with this. This is the trial has been concluded, and where is the power? We are very much concerned about that is the law. I have also fought it and went up to Supreme Court Constitution will decide it. If there is defect of the investigation is there, it can be handed over to the CBI or
official expert.
That is at the stage of investigation or at the stage of the trial. Not after the conclusion of the trial, any judgment is there. That your lordships can direct the CBI to make an investigation. The investigation is faulty. Of course, this court has power during the pendency. And if your lordships consider the two provisions, that's also clear. I have also consider this. Kindly come to section 193.9. First, 193.9. Come to provision. Provided that further investigation during the trial may be conducted with the permission of the court trying the case, and same shall be completed within a period of 90 days, which may be extended with the permission of the court. Therefore, the permission which was granted to the CBI by the trial court was supposed to be completed within a period of 6 months from the date of passing of the order. Because this power of the magistrate to direct further investigation only remains during trials. Next, my lord, kindly see section 358.
तो 4 का है इसके बाद
Section 350. Power to proceed against other persons appearing to be guilty of offence. Where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person could be tried exclusively. Now, for which such person could be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. Second, where such person is not arraigned, second and third is not required. Therefore, in course of trial, and here is a clear finding of the trial court, there may be laxity on the part of the others, but that will not can be said to be a faulty investigation, and therefore conviction order has been passed. I don't know whether the trial court judgment has been shown to your lordship.
No, that is not what.
They should have filed this subsequent event.
But one thing, Mr. Bandyopadhyay, you have also fought many cases. Do the statutory powers limit the constitutional courts?
Court cannot pass an order contrary to the statute.
No, this is not contrary.
Yes.
Whenever, suppose these in the BNSS or in the CRPC earlier, there was no provision for giving investigation to the central agency. Otherwise, magistrates could have easily granted aid to the CBI. Now, however, sanction provision was there, and under the DSP Act, and therefore, under Article 226, when orders were passed, the permission of the state were also not required in those circumstances. Now, when the High Court takes into account all these materials, either under 482 or 226, whichever the powers are, is it that because proviso clause is because of Ritanak's judgment, which I believe?
Kindly allow me to argue, please. See, point is, this is I argued that went up to Supreme Court, that the constitutional bench has laid down the law, and it was my research for 17 years.
I don't dispute that, sir.
Point is, when an investigation is defective and when an investigation is conducted in a biased manner, whether the High Court is having the power to direct, to transfer the investigation. Ultimately, Supreme Court has said, yes, Article 226 and Article 32 of the High Court, power of the High Court and Supreme Court is there to direct the transfer of an investigation, right? Now, that is a pending trial. Even a trial is going on, even in that case also directed to make an investigation. Is there any case where the Supreme Court has said, yes, we have transferred it, trial has been concluded, even then we can direct to transfer, make an investigation. The constitutional power, what your lordship is saying, that is up to the conclusion of the trial. That means one judgment of, I will show to, I have a number of judgments. Just one paragraph will make it clear. Madras law. You see, this is a Madras High Court judgment, 2013 1 MWN CR 267 DB. Kindly come to paragraph 2013 1 MWN, আমি দিয়ে দেবো MWN CR 267 division is kindly. The lordships will come and see the paragraph. Come to paragraph. এটা তো yes, come to paragraph 28 first. In Hansbai, Valibai and Qureshi and State of Gujarat 2004-5 SCC, in paragraph number 12 and 13 has been held as follows. Subsection 8 of section 82 permits further investigation. I was telling to Lord 173.8 earlier, which was there. further investigation.
No, further investigation was there.
I am saying
The proviso clause was not there. The proviso part which
it's same. Further investigation when? When? Further investigation provision was there. Proviso has made it very clear. Further investigation where? Magistrate how long? Or investigating agency can keep it for how long? Till doomsday. Is it the law? No, I could not finish it. We have a voluminous document. We have to look into that. If an investigating agency cannot finish it, they are liable for everything. Interest is must to take over the investigation. But you can't conclude the investigation. Read below. Subsection 1 of the court permits further. I am very little knowledge in criminal law.
No.
I am arguing before legal luminaries and others are also legal luminaries in the criminal branch. I don't know. They were, no, I have become nervous. Power is not there. I was arguing.
these cases you have done much more than others.
I have spent my 17 years and 1 year I did not earn a single paisa. I did not do any case in Calcutta High Court. Any private matter. I spent from my own pocket. This CBI as powerful because of my exercise.
That trial has been completed.
No, I am telling you, 19, no trial. 2001, 24 years, no trial. Riyanur Rahman, 2007, no trial. Then other cases, no trial, nothing. Only I have said in other cases, Khichberi photo. That is only, no trial has not been concluded.
Trial is going,
Going on, not concluded.
18 years.
18 years.
18 years.
They are claiming to be the prime agency.
I had a privilege to appear on
It is better to give a constable to the investigation.
that. I will not say.
Let see and come. In conduct proper even after the court took cognizance of any offence on the strength of police report earlier submitted, all the more. So it is in this case the head of the police department also was not satisfied of the propriety of the manner and nature of investigation already conducted. Now, so and so it was observed by this court that further investigation is not altogether ruled out merely because cognizance has been taken by the court. When defective investigation comes, when defective investigation comes to the light during the course of trial, it may be cured by further investigation. If circumstances so permitted, it would ordinarily be desirable that all the more, so in this case, that the police should inform the court and seek formal permission to make further investigation when fresh facts come to light instead of being silent over the matter, keeping in view only the need for an early trial, since an effective trial for real or actual offence found during course of proper investigation is as much as relevant, desirable and necessary as an expeditious disposal of the matter by the court. In view of the aforesaid position of law, if there is a necessity for further investigation, the same can certainly be done as prescribed by law. The mere fact there may be a further delay in concluding the trial. Concluding the trial, can't read it. Concluding the trial should not stand in the way of further investigation if that would help the court in arriving at the truth and true, real and substantial as well as effective justice. We make it clear that we have not expressed any final opinion on the basis. 29. From the above, there can be no difficulty to firmly conclude that any state, before the final conclusion of the trial court had got the power to order for further investigation. When the court is satisfied, the investigation is allowed. Therefore, after trial, magistrate is having power. If the we are in the High Court. No, don't continue. Please no. Don't pass any comments. Go stand there in that side. I am not passing any comments. With due respect. No. Don't do it. I'm just assisting. You assist there. Don't not within my ears.
No one have heard that I have to.
Don't show your arrogancy here. CBI is arrogant. We know about that. Don't do it here. I'm arguing this constantly. Tell your client, Mr. Majumdar, do not be afraid to your clients. Be a lawyer of High Court.
Yes, Mr. Please.
Now, therefore, what I was submitting. See, if the Mr. Majumdar says post incidents are there, for that investigation is required. A completely new case. No objection, nothing. I am not raising an objection. I am saying about the your point is, my lord, if the magistrate statutorily doesn't give the power, law is that if an investigation is defective, court can direct. That's the fundamental. That is the will of all cases. Even at the stage of the trial, it can be, if there is a fault, if the court says there is a fault in an investigation, court may direct for further investigation. And under the new act, when a further investigation has ordered to be directed to it has to be done within 6 months. Therefore, the point before your lordship is this: whether if the statutory power is not there, writ court is having the power. Can you revive the trial? If a trial cannot be revived, how the court can direct investigation? I have other judgments. I will argue on the next day. I have said I will have to leave. I have other judgments.
No, I know.
I have a very little knowledge in criminal law.
No,
I always scared in a matter when I appear, especially when Mr. Rajdeep Kojumdar and Mr. Sudipto Maitri appear. When I was doing in the Rijanur case, I will not take the name of all the senior counsel appearing against me were saying we have to go to the law classes. I had to hear that comments also. But indeed, I had to hear that from the senior counsel who was appearing from the other sides. But unfortunately for them, fortunately for me, that I won't. But I must say, Miller, one of the senior counsel, that the great Bolai Rai, when I was arguing, almost on the last day, he came out from the court before the delivery of the judgment. He said to me, Salman, I am happy that one lawyer has come. Even if I die, I will know that there is a lawyer in Calcutta. I am so grateful to him. They were incorrigible, but today's legal luminaries tell me that I don't know the law. No.
They don't treat after getting senior counsels.
On the next day I will, and if possible, your lordship keep it at 4 o'clock or 4:15, it will be with your lordship's permission.
Yes, please.
No, I have said, date is saying.
No, I remember, you have no, on merits, you don't have any objection. You have submission, so as the law is concerned.
Law is concerned.
Then it is for academic content.
No, academic or non-academic, that's a different thing.
See, on the instructions of the client, he has made his submission. As a lawyer, professional,
yesterday I said before the Honorable Chief Justice, in a Jadavpur matter, I submitted. It is not the instruction of my client, but as a senior advocate, I feel that Lordship should pass an order stopping all meetings within the Jadavpur constituency. Jadavpur means university. There should be a balance has to be created between a fundamental right and the normal public interest. Public is also enjoys the fundamental right. People of less.